Greetings and hello everyone. Welcome with Facebook Connect with Chee and Associates. As today we will share with you all of legal issues arising during MCO. And as of today, we are going to discuss on Know Your Tenancy Legal Rights. However, before we proceed further, allow me to introduce myself. My name is Sarah and I'm currently a legal assistant in Chee and Associates. And together with me is our principal, Miss Tiffany, and I will allow Miss Tiffany to introduce herself. Please welcome.
Thank you, Sarah. Okay, hi everyone, I'm Tiffany. So I believe you might have seen my face before if you have checked out our earlier video on employment law related matters during MCO and also post MCO. So today we will be sharing with you on this tenancy related legal matters, also in relation to MCO. So Sarah will explain to you what is the importance of tenancy agreement during MCO and also at all times. So yes, Sarah, could you please enlighten us?
You can see on the internet, there are a lot of tenancy agreement template. However, do you know that in Malaysia, there is no exact statute or law that governs the tenancy agreement, meaning that a good tenancy agreement will reflect a good relationship and mutual understanding between a landlord and also the tenant. Everything should be included inside the tenancy agreement, even though it is the slightest thing. However, during this MCO, a lot of people go back to their tenancy agreement and there are other issues that becoming a big question for them. So, Miss Tiffany, can you share with us what are among other legal issues that rise during the MCO?
Yeah. Okay. So during this MCO and COVID-19 period, are landlord legally obliged to waive rental payment of the tenant due to all these unforeseen circumstances? So can tenant rely on all these force majeure clause and says that, okay, due to unforeseen circumstance, I'm not able to have enjoyment of the property and hence I'm not responsible for any rental payment. So can they really say that and rely on that? So let us look at the residential setting. So well, it doesn't really make sense to invoke force majeure on residential tenancy agreement because obviously during this MCO, we are all obliged to stay home, just like how you and I are staying at home right now, right, Sarah?
Stay at home, yeah.
So the obligation under the tenancy agreement is not disabled as you are able and definitely have the means to occupy the premise. So how about commercial settings then? The enforcement of MCO has actually prohibited many businesses from operating and hence they were not able to utilize the premise and space. So can they invoke force majeure? So before a force majeure can be invoked, it must be proven that the responsibilities and the obligations between the parties have been completely disabled. So well, technically speaking, after 12 May 2020, the MCO will be lifted. Let's say if there's no further extension, right?
Let's hope.
Yeah. So MCO only act as a temporary measure and it's not sufficient to say that, oh, this is a force majeure situation. So hence it is highly unlikely that a force majeure clause can be invoked for commercial properties as well. Okay, so it's best that parties come to agreement and negotiate. And if the situation allows, landlords should always provide some leeway to the tenant so that they can maintain a long-standing relationship. Okay, let's say the tenant still couldn't pay up, have no means to pay up because the economic is just terrible for this period. What are the consequences of a breach of agreement? Okay, Sarah will share on that.
Yeah, meaning that right now, if the tenant unable to pay, they are already considered breaching the tenancy agreement, right? Hence, the general rule is always go back to your contract since this tenancy agreement is contractual obligation. So you need to look for those key terms inside the tenancy agreement, whether or not they set out the definition for termination, on the deposit matters for feature, notice to return vacant possession, and also what can the landlord opt to, whether for eviction or distress. So these are the key terms and the consequences that we're going to look through inside the tenancy agreement. I believe that our audience will understand better if we give them some scenario. So let's look here. Scenario 1. Upon expiry of tenancy agreement, tenant still occupying the premise despite eviction notice by the landlord. Can the landlord recover the premise by changing the locks? Meaning that they change the lock so that the tenant cannot come or cannot get out, for instance, right? In order to halal them, right?
Okay.
So the answer is no, except upon receiving order from the court. meaning that whatever you do, you need to get order from the court lah. So I give you another scenario then. Second scenario here. How about when the tenant is missing, is not there at all and not reachable by any means, yet the possession of property is still with tenant? Can I just go into the premise and change the law? So the answer, you can see that the landlord cannot go into the premise and change law as it amounts to trespassing. The correct and legal method is by way of filing writ of eviction. Even though you feel like, oh, this person is not going to come back, maybe I can come in and change the law or sell off some of his property or move his property. You will be conducting an act amounting to trespassing. And in return, maybe you can get legal action as well. So we don't want that for you, landlord. So you need to remember.
Correct.
The correct, yeah, right. You have to do it according to the law. So filing writ of eviction, by which we will assist you in understanding a bit lah after this. Kan?
Yes.
Because if you do that, you will, your self-help of claiming back your property is contrary to Section 7, Clause 2 of Specific Relief Act. Is that right, Ms. Chee?
Yes, correct. And furthermore, I think the audience should also take note when in your agreement, because sometimes it really happened, okay? My client came to show me his tenancy agreement. It shows that, oh, we can regain the vacant possession of the property by giving notice to the tenant. And that's it. No need court action, etc., etc. So this is actually directly contrary to the Specific Relief Act as mentioned by Sarah earlier on. Okay, so yeah, even though the tenancy agreement expressly state out, oh, we can regain by just giving notice, it is not applicable. So that clause is basically void and not enforceable. All right. So we can look further at other examples and other scenarios as well. So how do landlord evict the tenant and recover the premise? What is the right way? What is the right legal manner to go about it? So firstly, the landlord should always try to communicate with the tenant via telecommunication first maybe. So let's say if things doesn't work out between them, the landlord can start instructing the solicitor to post out a notice of demand to return vacant possession by the tenant. So, okay, let's say the tenant is okay, he will just return as it is. That's good for the landlord. So that one is like the less headache tenant. Let's say if you are encountering this tenant that gives you a lot of headache, he doesn't want to leave and he doesn't want to pay either. So what can you do? Okay, there are two ways to go about it. You can go for distress proceedings or eviction proceedings. So what are the differences between these two? Distress proceedings is when you get to file this writ of distress and there will be a bailiff from the court to go to the premise with you and we will start tagging the items, the fixtures, the valuables in the premise so that it can go through auction where the proceeds from the auction will be able to be recovered by you. So let's say the tenant is owing 30,000 to you and you manage to auction off how much? 25K. So there are still 5K short, right? That means you will still have to go by other enforcement proceedings to recover, but at least you get to recover a big sum of it, a majority sum of it. However, this distress proceedings doesn't provide a cause for you to evict the tenant. You will still need to file an eviction. So let's say the tenant is not cooperative. He still doesn't want to leave even you have filed a distress and auction off his property. So you will have to go for eviction proceedings then. Okay, so practically speaking, normally lawyers would advise their client to go for eviction proceedings when you know for sure that there's not much valuables in the property and the landlord, the tenant has no means to pay up as well. So they will just file this eviction to evict the tenant in a legal manner. So these are the main difference between these two and they are to be resorted at different circumstances. So it really depends on your situation. Okay, normally for commercial settings, people probably will go for distress proceedings instead of eviction because there are surely a lot of equipment or even goods in the commercial settings. Okay, scenario 4. What if the tenant wished to terminate the agreement earlier, whereas the landlord refused to refund deposit and proceed to claim for the remaining period of the tenancy agreement? Can they do that? Okay, let's say the agreement has 2 years. It's 2 years period, all right? But at the first year itself, the tenant has said that, oh, I don't want to stay in here anymore. I don't want to rent this place anymore because I'm not generating profit from here. So can they do that? Can they just leave and ask for a refund of deposits. If your landlord is kind-hearted, yes, of course. But if not, then they will refer back to the agreement. And if the tenancy agreement provides a clause that to say that landlord can claim the remaining period sum of the tenancy agreement, then legally speaking, yes, they are allowed to do so. Even if you never occupy the place and you don't enjoy the premise for the remaining 1 year, you'll still be obliged to pay it. So the importance of a well-drafted tenancy agreement and a balanced interest agreement is very crucial for both parties. Or else you will be like this scenario 4, like tenant in scenario 4, you will have to pay extra for all this. So you might as well continue occupying the place. It's like there are no exit clause. We call it no exit clause for this particular tenant. So it's really important for you to vet the agreement properly and understand that this is what you want and these are the consequences. Okay, so yeah, I believe all these scenarios will have helped you to understand better on tenancy related legal matters, and I hope that this video have enlightened you and made you a more knowledgeable person in a way. All right, so thank you for staying in and tuning in to this video. We hope that we will see you again on our next video. All right, so okay, Sarah, what will we be sharing on the next video? Something exciting? Keyboard warrior?
Yes. Right now you are stuck in your home and then you have so many times on social media and you feel like you can express your feeling freely. However, be careful not to defame other people. So our next topic is on defamation.
Yes, whether it is freedom of expression or are there limitations to this freedom of expression, freedom of speech? Because sometimes this freedom of expression would lead to a trial by social media, which is something that is really disastrous for the victim themselves. So we will discuss further on this topic and we hope that you will tune in as well to find out more. Okay, so thank you for staying in again. All right, we will end our video here and we will see you next video. Bye.
Bye-bye.